but you are opening yourself up to, since you said like 400,000 sites are using single sign-on for Facebook. So currently, the only Facebook login you have is, say, your email address and a password. Is there any mention of implementing like a two-factor type authentication in a single sign-on service where you add a password and biometrics signature, or a password and a separate token?
I understand. So even OpenID and OAuth, both basically is that I have mentioned that you can choose your identity provider, right? That identity provider can select how they will authenticate you. It could be two-way, like you say, and it could be even 3 ways if they can invent a different one. Yes.
But the other organizations would have to accept that.
Exactly. And they need to provide that API. But the problem is they're not getting anything from those OpenID, so they're not willing to. They're getting more from Facebook than they will provide the Facebook API.
Okay. Yeah, so could you please authentication verifies? Could you actually set which websites pertain to what? Could you actually change different attributes?
I'm sorry?
So if you go to Facebook and you only use Facebook certain set of attributes, and then let's say I go to another website, another set of attributes.
So you're talking about a single sign-on using Facebook, or
the multi
okay. Yes, you can get different attributes for, and you can show different attributes to different sites.
I see. Okay.
Yeah.
The fear of sounding like I work for a company. Have you looked into Mozilla Persona at all? It's similar to OpenID or OAuth, I guess, but it's decentralized and email based.
I'm sorry, I didn't look at that.
I would agree to say what you think.
Okay, thank you. I will. Yes.
So you had OAuth, which offers kind of a specific token. Is it a one-time use token or a token that has set?
So yeah, for OAuth, the general case is temporary tokens, which will expire soon. Soon means like you can't use twice, but a session. You can say you can use that for a session, not for the next session.
Whereas, like for ID where it offers a certificate, you can store that, store it locally, and then use that whenever you need.
All right. So for the certificates, there are like 2 options. One is offline, one is online. So for offline certificates like X509, you can store the certificate and use for different cases. But what I showed in OpenID is like on the fly. You will ask that identity provider that show me the certificate or send it to that. It will be given a URI or something like that. You need to just talk.
Thank you. Okay, next up we have Tyler.
Let me just organize. Yeah. So don't trip over these wires. Yeah. Okay. So I need that full screen. You want you? Okay, cool. So, how's that? Good? All right. I'm Neil Tristida. Tyler Romeo.
Yeah.
So our presentation is on domestic surveillance and privacy. We specifically looked at a law here. So I think we all heard many different disclosures of NSA. We've heard about various programs that they have, and in two lights we have two rationales. The first rationale is it's for national security. The second is it's an abuse of power. Okay, yeah.
No, it's cut off.
It's cut off, yeah. So
Let's continue.
the first rationale is, we're using these programs to connect the dots. Specifically in, the attacks of 9/11 probably could have been prevented if we had a way of, connecting those dots of, illegal travel, money transfers, and this is what NSA is looking for. However, there's kind of there's a disconnect in perception. And in two lights, the NSA believes that the laws are constitutional, and the protocols for data collection are being met under the executive order of the president and the surveillance laws in place. However, there's much of the public and privacy activists see this as an abuse of power, and there's been almost lies. We've heard Keith Alexander, say 50 terrorist plots have been prevented. Well, that's really not the case. So there's definitely a disconnect in perception of NSA programs.
Yeah, so the reason why we decided to go into this topic was because it really affects a lot of people. There are a number of individual stakeholders that have different interests in surveillance, in government surveillance, in data collection. The most important one is obviously the general public. So the general public is the people whose rights are involved here. You also have both the policymakers in our government as well as foreign governments who are both interested in the data that is being collected from the United States citizens. The United States government has its own interests, but in addition, it may or may not be sharing data with other governments, specifically our allies, in order to sort of collectively determine if there are any terrorist threats. And then, of course, we also have privacy advocates and the Privacy and Civil Liberties Oversight Board, who are both trying to advocate on behalf of the general public for their privacy rights. The PCLOB, as we'll discuss later, is another slide. Yeah.
So just going off of, let's talk about NSA operations. So most of the programs that Edward Snowden disclosed were under the tailored access operations. The two biggest happen to be a program called Turmoil. Turmoil is a global surveillance system, and what it is it's a set of passive set of sensors. Any data that flows through these sensors, NSA looks at. This has been compared to deep packet inspection. However, this is on a global scale. These sensors are placed strategically around countries, especially around the United States too. So if Turmoil is deep packet inspection, Turbine is deep packet injection. And what the NSA does with Turbine is it's basically again a global surveillance system that exploits countries' infrastructure on a large scale. The NSA performs what is known as man-on-the-side attacks, and what it does is it will trick a group of people into thinking that they're actually accessing real content. In reality, they're connecting to NSA's servers. The NSA, though, their point of view is, it's only considered surveillance after they collect it, after they record it to a database, analyze it with algorithms. They only consider this surveillance only if a NSA analyst personally looks at it. So what they're doing here is they're almost defining privacy, and this is fundamentally wrong. Also, too, is if any of us ran a system like Turbine, you know, we would be thrown in jail. You know, there's something wrong. So the NSA has at least, it's been estimated, I think by the New York Times, published an article, at least 15 years of data retention. And this includes content. And what they do with this data, combined with metadata, they begin tasking. And by tasking, they create selectors on a specific target. And this includes maybe IP address, phone numbers, voice prints, and they basically begin building a profile. So some of the programs that we've heard of so far, there's a large list. I can show that in a second. The programs that we're going to focus on are Prism, Bullrun, XKeyscore, Quantum, and Dishfire, and Echelon. So I don't know if you heard, but basically Prism is a data mining program. It collects internet communication from various sources like Google, Facebook, Apple, and others. They collect this material, you know, such as file transfers, live chats, search history, and what they do is they demand information from from these corporations, and we'll get into the law of how they can demand this information. The second program is Bullrun. Bullrun is a is NSA's decryption program, and this mainly was focused on HTTPS. So websites from Facebook, Google, and Microsoft. The NSA will attempt to decrypt traffic, encrypted traffic. I think this was one of the programs that was sifting data off between Google's data centers. And there's no, in the disclosures, there's no really technical information on exact cryptanalysis, NSA's cryptanalysis capabilities. The next program is XKeyscore. So XKeyscore is it's a program that allows analysts to search with no prior authorization through vast databases of based off of any of the selectors that were found or put together in Turbine and Turmoil. So it allows analysts to basically search a vast database, of emails, online chats, browsing history, and this database is thought to contain millions of individuals' content. Echelon is a signal intelligence program. It's used to intercept satellites, cell phone, and other wireless communication. It's one of the oldest programs so far. I think it was created in '99. Let's go to the next one. Okay, so legal overview. So what protects? What privacy laws do we have? The first one we'll get into is called the Privacy Act of 1974, the Electronic Communication Privacy Act, and we'll go into the Fourth Amendment. The Geolocation Privacy Act and Surveillance Act has not been passed yet. We'll talk about it, though. So the Privacy Act of 1974, it basically restricts the government in the collection, use, and dissemination of personal identifiable information. The Act prohibits any disclosure without written consent from individuals. However, there's 12 statutory exceptions. I've listed 5 for the most important ones here. The first one being is statistical research. So government agencies are allowed to collect any information they collect. They're allowed to run statistical research on it. Another thing is for archival purposes. This is a direct. So basically, any record which has significant historical or other value to the U.S. government. The other thing is for law enforcement purposes. They don't really define in the Privacy Act law enforcement purposes, and this is almost a vague where the Privacy Act becomes vague. There's no definition of what purpose they can have and what they can't do. Another interesting thing is consumer reporting agencies. So, they can report any of the information, any financial information. They can report to credit card reporting agencies, insurance companies. So these exceptions kind of stray away from, I think, the purpose of the Privacy Act. So another thing too is it's supposed to protect the privacy and civil liberties rights of individuals, and there must be a reason. And if we look at the NSA programs, we do have reason. We do have reason when we do have executive order from the president, and this almost authorizes NSA's domestic surveillance programs, the programs that I mentioned before. So they're kind of in coherent. They're kind of in. They're able to, under the Privacy Act, they're able to conduct these programs. The next law we'll look at is the Electronic Communication Privacy Act. It was enacted to prevent unauthorized government access to private electronic communication. Now we'll see in the FISA amendments that this act is almost voided, and there's almost a clash between these two laws. It restricts the wiretaps from telephone calls to include transmission. So it restricts collection of telephone calls, which include transfers of electronic data by computer. In addition, information that's stored on any third-party servers for more than 180 days by law is considered abandoned. All that is required to obtain is the content of email or any form of data is a written statement. Okay. So the Fourth Amendment. So I think we know what the Fourth Amendment is. It's part of the Bill of Rights. So the Fourth Amendment prohibits unreasonable search and seizure and requires any warrant to be judicially sanctioned and supported by probable cause. So there's two requirements here. There's both a warrant requirement and both a reasonableness requirement. So this represents two distinct interpretations. In some situations, courts will actually forego warrant requirements, even though a warrant requirement may be a stricter standard, and actually forego a warrant requirement and apply a reasonableness requirement. As I said, the warrant requirement is generally more stricter, but it also these two requirements both give citizens protection, but it also gives the U.S. government more leeway. So the interpretation of kind of the Constitution right now has been changed a bit because it prohibits the search and seizure, but there has been no case law right now, nor law that determines whether wiretapping, collection of emails, exploiting a U.S. person's computer is considered a search. So what they're doing is they're almost changing what search and seizure means, and they're kind of going around it. More importantly, go down. Oops.
Neil, do you not know how to scroll?
Sorry. More importantly, there's case law that rules upon these two approaches. The first one being is Miller U.S. versus Miller. This was a 1976 case which ruled upon the Fourth Amendment, and the second case is Smith versus Maryland. Miller was basically involved in warrantless access by law enforcement agencies to a suspect's bank record without any prior warrant. The thing that came out of this, the ruling that came out of this, was probable cause. A warrant was not needed. The second case involves tapping a suspect's phone using, I guess, something called a pen register. In both cases, as I said, I'll say again, probable cause for suspicion was the only thing that was needed. Here, a warrant was not even taken into consideration, and these two became important Fourth Amendment cases. It changed this. It tested the scope of what the Fourth Amendment means. So this one, this law, the Geolocation and Privacy Surveillance Act, it really hasn't been passed. It was introduced to Congress in 2011, and it still awaiting congressional, Congress as well as Congress to rule on this. But what it does is it places restrictions on government surveillance using geolocation information. If this law would have passed, many of the metadata programs that NSA is currently doing would probably be illegal or maybe even better to be stopped. It was designed to give government agencies and commercial entities guidelines of how to use geolocation information.
Okay, so what we've been talking about so far is mainly privacy law. So all the laws that we've looked at are determining what the government can do with your data once they have it. It's determining how the government can share your data, how they can process it, but what we haven't looked at is surveillance law, which concerns how the government is collecting your data. Now, outside of normal means, so the information that you normally submit to the government voluntarily, which, submitting your tax forms or whatnot, there are certain acts and amendments that allow the government to perform surveillance on you in what's called ex parte, which means that they're not notifying you of the surveillance. You are not aware that this data is being collected, and then once it's collected, it is being used under the aforementioned privacy acts that allow them to perform statistical research, share with law enforcement, and so on. So the first thing that we're going to look at is the FISA Act, Foreign Intelligence Surveillance Act. It is the first surveillance act that was entered in. But in order to understand why this act was put into place, we sort of need to start back at the beginning to find out, well, what is the history of the USA's opinion on surveillance? Well, it actually begins back in 1928. So in 1928, this was back when surveillance really wasn't that much of an issue, and the United States was still operating under, believe it or not, common law from the United Kingdom, back when we were in the British Empire, where courts sort of established that it didn't really matter how you got the evidence as long as you had it. So the method through which it obtained didn't really matter. So in one case, which is Olmstead versus United States, the court actually ruled that wiretapping did not consider a search and it did not violate your Fourth Amendment rights. So from 1928 on, wiretapping was basically legal without a warrant because it wasn't considered a search. That, however, was overruled when we got to 1967. So as you guys may know, the right to privacy is not something that is in the Constitution. It is not something that is explicitly said as one of the rights of the United States citizens. It is something that was created or almost fabricated out of other amendments through case law. And this happened in 1967 with Katz versus United States. It's almost the exact same case as Olmstead back in 1928. Someone was using a public payphone, and the government decided that they were going to wiretap them. And then the government decided to use that wiretap information in a criminal investigation. Now, in this case, however, it was appealed to the Supreme Court, and the Supreme Court ruled that it did constitute a search. Specifically, a quote from the Chief Justice at the time on the majority opinion was that the government's activities in electronically listening to and recording the petitioner's words violated the privacy upon which he justifiably relied while using the telephone booth. So in other words, this is where sort of Justice Stewart came, looked at the Fourth Amendment and other amendments, and said there is a reasonable expectation of privacy here where, if violated, requires a warrant because it constitutes as a search or seizure. Almost immediately after that, in 1972, there was another case, United States versus U.S. District Court. And the case here was a little bit different. So back in Katz versus United States, one of the things that the court explicitly noted is that they weren't addressing issues with national security. So directly quoted from the case, it expressly left open whether safeguards other than prior authorization would satisfy the Fourth Amendment involving national security. So anything that had to do with violence or individuals being put into danger was not covered until this case in 1972, where something known as the White Panther Party, which was an anti-racist party, was conspiring to destroy government property. And under the Omnibus Crime Control and Safety Act, the government decided that they were going to surveil them without a warrant. And this was appealed to the Supreme Court, and the Supreme Court obviously shot them down, saying this is surveillance, you need a warrant, and this does constitute a violation of Fourth Amendment rights. And the reason is because one of the senators that was involved with the case, Philip Hart, basically stated that the president could, just by executive order, declare anybody to be a threat to the United States and thus surveil on them without a warrant. However, what none of these cases have addressed is foreign surveillance. So right now we've just been focusing on United States citizens who have been wronged in some way and then appealed to the Supreme Court. Now, despite the controversy on domestic surveillance, there is actually no controversy on foreign surveillance, to the point where there are actually no Supreme Court cases concerning foreign surveillance. There are two cases, United States versus Brown and United States versus Patenko, which both were in the Third and Fifth Federal Circuit, respectively, but they were not granted certiorari and they never made it out of appeals court. So, and both cases ruled that when it comes to foreign surveillance, a warrant really isn't required. So the court, for the most part, agreed that foreign surveillance did not require a warrant because it did not violate the rights of people that are protected by the Constitution. Now we actually get to the FISA Act, which basically cemented this in law. It made the statutes that spelled out what was needed in order to perform foreign surveillance. It was it was created to specify the exact process through which foreign surveillance was conducted. And it stated that if there was a non-U.S. person involved, and the definition of foreign entities was defined back in the National Security Act, and that means that if anybody outside the United States that is a non-American is one party of the communication. So if the other party can be a United States citizen, but if the other one is a non-U.S. citizen or outside the United States, then a warrant may not be required, in which case all they have to do is certify under a secret court that was established by the Act, and then they can surveil up to a year without renewal. Alternatively, if there is a case where they do need a warrant, they can obtain a secret warrant where the person will never find out about it, and then continue to perform surveillance on that person. So that was back in 1978, and it was quite a while ago, and it was in the midst of the whole, well, I'm not going to go into what happened in the 70s, but you get the point. The next act that came up was up in 1994, and this is sort of an intermediate step. It wasn't really that big a deal, but it's been amplified by later acts, which we'll go into. And this is CALIA, which stands for the Communications Assistant for Law Enforcement Act. And it required that all telecom companies install basically helper equipment for the government in their systems. So they needed to make it easier for the government to perform surveillance on people. And this applied to both old and new equipment. So telecoms had to alter their existing infrastructure in order to make wiretapping easier for the government. Now, this did not change any of the warrant requirements concerning surveillance. However, it did open up the possibility to more surveillance by the government by making it easier for communications to be intercepted. So now we get into the Patriot Act, which is everyone's favorite. This came right after 9/11. It's actually a very, very widespread act. It covered a lot of things. We're going to focus on Title II, which concerns surveillance. The first couple of sections, 201, 202, and 203, basically expanded what the government could perform surveillance on. And it said that if something had to do with surveillance, or if it had something to do with terrorism, then a federal judge could approve a warrant without telling the person, and then they can start surveilling on that person. So the difference between this and the FISA Act is that before, if there were two United States citizens that were communicating with each other, you needed a warrant straight up. It was not considered foreign surveillance, so it did not fall under the act. But now, if the government believes or has reasonable belief that there are two U.S. citizens communicating about something concerning terrorism, now all of a sudden that falls under it, which means that they can go to a secret court, get a warrant, and start performing surveillance on those people without telling them. And then there's also Section 203, which is not really as significant, but it allowed the government to begin disclosure of grand jury testimony. So grand jury testimony is usually completely secret. You're not allowed to disclose it outside of the chambers, regardless of whether you're on the grand jury or the reporter for the grand jury. It doesn't matter. But now they could be disclosed if anything discussed during the grand jury testimony is considered foreign surveillance. The next couple of sections concerning roving surveillance, and that's basically putting something on your cell phone or performing surveillance from a location that is mobile and moves around. And it sort of gave, in the words of the EFF, gave the FBI a blank check to violate people's Fourth Amendment rights. We're going to move on for the sake of time. Section 217, a little also not as controversial, but basically, if you're hacking a computer system, if you are, a black hat hacker and you don't have authorization to access the system, you are completely subject to surveillance no matter what, because you are violating. Are just amendments to the original FISA Act from 1978. This one is the Protect America Act. It was the first step in what are the more controversial amendments to FISA. This act removed the warrant requirement for government. So, in direct quote from the law, reasonably believed to be outside the United States. So now you no longer had to know that somebody was outside of the United States. The government just had to reasonably believe that they are, and then they could conduct warrantless surveillance on that person or those people, as long as there was some sort of belief that they were, at least one party was outside of the United States. And the warrant requirement was instead replaced with internal NSA controls, which we all know how that turns out. Then we come up to the FISA amendments, which was the next year. One of the first things that did was the government realized that they didn't want individuals to start suing the telecom companies for the government surveillance. They wanted the government to sort of have complete control. So they have this release from liability, which grants the communication companies complete freedom from any type of prosecution with regards to government surveillance. So everything from the CALIA, from all the equipment that they need to install, the telecom companies no longer need to worry about that. In addition, this act also increased the amount of time that you could perform surveillance without having to certify a warrant from the FISA court from 48 hours to 7 days. And in addition, now you could perform surveillance on somebody, not without a warrant, and then just tell the FISA court afterwards, within 30 days, that you performed the surveillance. So now it greatly relaxed the requirements in which you needed to actually obtain a warrant. This actually brought up a case that we'll discuss a little bit later called Clapper versus Amnesty International, which is where somebody was being surveilled by the government, and they argued that because of this act, they were being off-put. They needed to encrypt all their activities just to make sure the government wasn't doing what they were doing. But we'll get more into that later. Now we're going to talk a little bit about the PCLLB.
So the PCLLB stands for the Privacy, Civil Liberties, and Oversight Board. It was created in 2004. There are 5 appointed members, and what their mission is basically to advise policies and civil liberties when appropriate. And they're basically to oversee the implementation of these policies while protecting privacy and civil liberties. Some notable events. Skip that. So around May 2007, the original member, one of the 5 members, resigned, claiming that the White House was basically editing content in their board reports. And this is kind of serious. This is kind of, the White House and government trying to almost redact and black out many of the NSA programs and actions. By October 2012, the group first had a public meeting. By November 2013, a substantial meeting was basically held to talk about metadata programs. This was almost compared to stop and frisk programs. So the PLB on June 21st came to a conclusion that PRISM was illegal, and it was 3-2 vote, and they provided legal basis for NSA's bulk data programs. There's 4 legal bases. The first one being the records acquired under the program have no connection to any specific FBI investigation. The second, putting telephone records on the program operates by putting telephone records on a daily basis as they're generated and puts them in the possession of the NSA, and it lacks any statutory that was in the FISA amendments. The third rather is any of the data that's being collected isn't relevant to any FBI investigation. It's out of the scope of current law right now. The last one is the statutory, only permits. NSA is only a foreign intelligence agency. The statutory, our current law right now only permits FBI to conduct these actions under specific investigation.
Yeah, so we're gonna go over this really quickly because we're kind of running out of time. But there are 3 cases that are actually involved completely in the NSA controversy, in that these cases are actually people suing the United States government with regards to the NSA's actions. It began with Joel versus which is 2010. That case is actually still going on. It's been appealed, it's been dismissed, and then undismissed. Same thing with EFF versus CIA. Yeah. Basically, there are now people that are suing the government for this warrantless surveillance. They aren't really getting anywhere right now. We'll see if they get anywhere in the future, but it is doubtful, as evidenced by Clapper versus Amnesty International, which I mentioned before. That case was actually dismissed by the Supreme Court because they determined that they did not have the necessary prerequisite of suspicion to sue the government. So they didn't have enough qualifications to actually file a lawsuit, which is why it was dismissed. So it is doubtful that unless there are specific damages that somebody can point out from the surveillance, that a case against the NSA will actually make it. So we're gonna gloss over this a little bit so we can let you guys look a little bit at the data. So we did put out a survey. These are sort of some basic demographics from the survey. We received mostly male, some female, mostly full-time students, basically people at Stevens. We did receive a good mix of political affiliations, which we did like. And we also did receive some people who are not undergraduate students, including some PhD and postdocs, so it was nice to sort of get a somewhat mix of people. In terms of the actual answers to their questions, most people believe that the NSA's actions were either completely illegal or legal but not constitutional. There were very, very few people that said that the NSA's actions are both legal and constitutional and should remain legal. So we asked them both on the terms of legality, on terms of constitutionality, and on terms of whether it should remain legal if it was. We also had a question where we put a bunch of NSA terms and programs and mixed them with sort of fake programs to see how many programs people could actually identify. And the results were almost a little bit inconclusive in that everyone recognized Prism, and then almost nobody recognized anything else. As you can see, there are some people who recognize Echelon and Keyscore. I actually forget, is Boundless Informant an actual program?
It is.
It is, okay. So yeah, there are some people who recognize some of the other programs, and then there are a small minority that sort of picked all the placebos. I think we actually had one. Yeah, we had one that was called Slideshow that a couple people actually picked. This cutoff is really killing me. This question that we asked is, what do you think the NSA has on you? So what information do you think the NSA has been collecting? And almost across the board, you can't really see the numbers because it's cut off, but this is around like 85% and this is 100%. Almost everyone thought that the Facebook knew. Almost everyone thought that the NSA knew pretty much everything about them, with the exception of in-person conversations. So, personal email, Facebook profile, even Facebook private messages, and your obviously Skype video calls and phone calls. Everyone across the board pretty much knew, or at least thought they knew, that the NSA has access to all of this stuff. Then we also asked, as a bit of a follow-up question, are the NSA's programs helpful? And surprisingly enough, a lot of people thought that either they have helped stop terrorist attacks or that they will begin doing so in the future. So this works out to about around 65 to 75% of people combined thought that they were helpful in some way, which was interesting. And then on a related note, we asked the survey participants, is there still a threat of terrorism? And there are a lot of people that think that there is still a threat of terrorism. However, there are still other significant issues that need to be handled first. And there are very few people that actually thought that there were not any remaining terrorist threats in the United States. With that, that sort of concludes the presentation. So now we will enter question and answer. Yes.
Going off of your statement, saying that NSA could sort of like create fake sites and view them or whatever. Do you happen to know of ways one could identify those? Or
so actually, in the disclosures, there's no disclosure of capability or even technical details. The disclosures and leaks were basically, here's what NSA is doing. There really wasn't, say again, technical detail. Yeah, technical details or that would give anyone a glimpse into how to prevent this. Yes.
You mentioned the terrorism that like one to assert.
That was the Patriot Act.
Just like mentioning the word or like the actual intent.
It's very abstract.
Yeah.
It doesn't really specify anything other than that there is a reasonable belief. I don't know offhand, but that might even be the exact words, reasonable belief that they are talking about, or that it will reveal terrorist information.
What it comes down to is probable cause. So, how much, confidence would they deem a target would have?
You guys mentioned how there's the geolocation privacy and surveillance act
Yes.
going through Congress.
Yes.
In response to all these programs coming to life, did Congress introduce any more laws that are going to they're trying to pass or anything like that? Have you seen any of that?
There definitely have. Most have been debated, shut down. I think the only one that's kind of still up is the geolocation and surveillance. Yeah, because that places guidelines not on government, but it also places restrictions on commercial entities. Yeah.
Do you guys know the Talia Act? That sounds very similar to prison, but kind of what ways that
Take this.
I don't know really.
So the Communication Privacy
Yeah.
Act.
Calia.
Calia. Okay. I mean, it is very interesting to see how these programs are partitioned. They do take advantage of certain laws. I would think yes. I would think that if I was putting together some of these programs, I would try to set the boundary so that they don't, so that they are within the bounds of certain laws. I don't know if that answers your question. Yeah.
So have your opinions changed on the NSA after this research?
More or less, yes.
Okay.
There are two rationales. One for national security and one for privacy. Yeah, I have.
Have there been any updates to the Privacy Act of 1974 in the past 40 years since it was passed?
I haven't. There was an amendment to it, I think in 1986, but I think that's about it. I think the Privacy Act, definitely needs to be rewritten, amended with our current times.
Seems like a lot of legislation's out of date.
Yeah, absolutely, especially in the Privacy Act, especially the statutory exemptions.
Yeah, I mean, as you've seen, the FISA Act itself was first put in place in 1978, and it was only until 2007 that they began amending it for the whole NSA program.
Yeah.
So, I know you guys really focused on the USA, our laws, but do you come across any kind of European laws that make these basically illegal? Do you have any off the top of your head?
So the FISA amendments, we really focused on domestic surveillance because that's the crux of the problem. Yes, surveillance, in general is, invasive and it is against privacy, but we mainly focused on domestic surveillance and looking at, foreign laws and interpretations is kind of out of the scope.
Yeah, so I mean, more of I'm going towards is there any equivalent? They say, you can't do these things, say in the EU, to violate their privacy. Would any of these or all these programs be illegal there? Or do you have any idea at all?
We didn't really look into international law.
Okay, so one last question and then we'll move on.
Can you provide a little more insight as to how foreign surveillance is defined? So if you have domestically, one U.S. citizen and one non-citizen, is that considered foreign? Or if two U.S. citizens are outside of the U.S., is that considered foreign surveillance?
Yeah, I can get that. So it was defined by the National Security Act of I think it was 1947, back when the NSA was originally established, and it's basically 2 U.S. citizens in the United States is not foreign surveillance. Anything else is foreign surveillance. So if you're a United States citizen outside the United States, if you are a non-U.S. citizen in the United States, or if you are a non-U.S. citizen outside the United States, and that only has to be one party. So
yeah, between 2 U.S. Citizens, it really comes down to probable cause. It comes down to probable cause, and if there is enough reason, the FISA courts will decide.
Okay, thank you. Okay, so I think next up is